Amendment 14. The 14th Amendment, Due Process Clause, by Nathan S. Chapman and Kenji Yoshino. The Due Process Clause of the 14th Amendment is a source of a array of constitutional rights, including many of our most cherished and most controversial. Consider the following rights that the clause guarantees against the state's procedural protections, such as notice and hearing before termination of entitlements, such as public-funded medical insurance, individual rights listed in the Bill of Rights, including freedom of speech, free exercise of religion, the right to bear arms, and a variety of criminal procedure protections. Fundamental rights that are not specifically enumerated elsewhere in the Constitution, including the rights to marry, right to use contraception, and the right to abortion. The Due Process Clause of the 14th Amendment echoes that of the 5th Amendment. The 5th Amendment, however, applies only against the federal government. After the Civil War, Congress adopted a number of measures to protect individual rights from interference by the states. Among them was the 14th Amendment, which prohibits the states from depriving any person of life, liberty, or property without due process of law. When it was adopted, the clause was understood as meaning that the government could deprive a person rights only according to law applied by a court. Yet since then, the Supreme Court has elaborated significantly on this core understanding. As examples above suggest, the rights protected under the 14th Amendment can be understood in 3 categories. 1. Procedural due process. 2. The individual rights listed in the Bill of Rights, incorporated against the states. And 3. Substantive due process. Procedural due process. Procedural due process concerns the procedures that the government must follow before depriving individual right of life, liberty, or property. The key questions are: what procedures satisfy due process? And what constitutes life, liberty, or property? Historically, due process ordinarily entails a jury trial. The jury determines the fact that and the judge enforces law. The past 2 centuries, however, states have developed a variety of institutions and procedures for objurgating disputes, making room for these innovations. The court has determined that due process requires, at a minimum, 1. Notice, 2. An opportunity to be heard, and 3. An impartial tribunal. Melaine versus Central Hanover, Beck, 1950. With regard to the meaning of life, liberty, and property, perhaps the most notable development is the court's extension of the notion of property beyond real or personal property. In the 1970 case of Goodberg versus Kitty, the court found that some governmental benefits, in that case welfare benefits, amount to property with due process protections. Courts evaluate the procedure for depriving someone of a new property right by considering 1. The nature of the property right, 2. The adequacy of the procedure compared to other procedures, and 3. The burden that other procedures would impose on the state. Matthews versus Enrage, 1976. Incorporation of the Bill of Rights against the states. The Bill of Rights comprised of the first 10 amendments to the Constitution, originally applied only to the federal government. Byron versus Baltimore 1833, those sought to protect the rights from state governments and to rely on state constitutions and laws. One of the purposes of the 14th Amendment was to provide federal protection of individual rights against the states. Early on, however, the Supreme Court foreclosed the 14th Amendment privileges or immunities clause as a source for robust individual rights against the states. The Slanderhorse case in 1873, since then the court has held that the Due Process Clause incorporates many, but not all, of the individual protection of the Bill of Rights against the states. If a provision of the Bill of Rights is incorporated against the states, it means that the state governments, as well as the federal government, are required to abide by it. If a right is not incorporated against the states, it applied only to the federal government. Celebrated debate about incorporation occurs between two factions of the Supreme Court. One side believes that all the rights should be incorporated wholesale, and the other believed that only certain rights could be asserted against the states. When the partial incorporation faction prevailed, its victory ran somewhat hollow. As a practical matter, almost all the rights in the Bill of Rights have been incorporated against the states. The exceptions are the Third Amendment's restriction on quartering soldiers in private homes. The Fifth Amendment's right to a grand jury trial. The Seventh Amendment's right to jury trial in civil cases. The Eighth Amendment to prohibition and excessive fines. Substantive due process, the court has always deemed, and the due process guarantees the Fifth and 14th Amendment to protect certain substantive rights that are not listed or enumerated in the Constitution. The idea is that certain liberties are so important that they can be infringed without a compelling reason, no matter how much process is given. The court decision to protect unenumerated rights through the Due Process Clause is a little puzzling. The idea of unenumerated rights is not strange. The Ninth Amendment itself suggests that the rights enumerated in the Constitution do not exhaust others retained by the people. The most natural textual source for those rights, however, is probably the Privileges and Immunity Clause of the 14th Amendment, which prohibits states from denying any citizens the privileges and immunity of citizenship. With the Slanderhorse cases, 1873, foreclosed that interpretation, the court turned to the Due Process Clause as a source for unenumerated rights. The substantive due process jurisprudence have been among the most controversial areas for Supreme Court adjudication. The concern is that fine unelected justices of the Supreme Court can impose policy preferences on the nation, given that, by definition, unenumerated rights do not follow directly from the text as a constitution. In the early decades of the 20th century, the court used the Due Process Clause to strike down economic regulations that sought to better the conditions of workers on the ground that they violate those workers' freedom of contract, even though this freedom is not specifically guaranteed in the Constitution. The 1905 case of Lochner versus New York is a symbol of this economic substantive due process. It is now widely reviled as an instance of judicial activism. When the court repudiated Lochner in 1937, the justices signaled that they would treat carefully in the area of unenumerated rights. West Coast Hotel Corporation versus Parrish, 1937. Substantive due process, however, had a renaissance in the mid-20th century. In 1965, the court struck down state bans on the use of contraception by married couples on the ground that it violated their right to privacy. Griswold versus Connecticut, like the Freedom Contract, the right to privacy is not explicitly guaranteed in the Constitution. However, the court found that unlike the Freedom Contract, the right to privacy may be inferred from the penubras or shadowy edges of rights that are enumerated, such as the First Amendment's right to assemble, the Third Amendment's right to be free from quartering soldiers during peacetime, and the Fourth Amendment's right to be free from unreasonable searches of the home. The penumbra theory allowed the court to reiterate substantive due process jurisprudence. In the wake of Griswold, the court expanded the substantive due process jurisprudence to protect a panoply of liberties, including the right of interracial couples to marry, 1967, the right of unmarried individuals to use contraceptions, 1972, the right to abortion, 1973, the right to engage in intimate sexual conduct, 2003, and the right of same-sex couples to marry, 2015. The court has also declined to extend substantive due process to summarize this as the right to physician-assisted suicide, 1997. The proper methodology for determining which rights should be protected under substantive due process has been hotly contested. In 1961, Justice Harlan wrote an influential dissent on Paul versus Allman, maintaining that the project of discerning such rights has not been reduced to any formula and must be left to the case-by-case adjudication. In 1997, the court suggested an alternative methodology that was more restrictive. Such rights would need to be carefully described, and under that description, deeply rooted in the nation's history and traditions, and implicit in the concept of orderly liberty, Washington versus Glansberger, 1997. However, in recognizing the right to same-sex marriage in 2015, the court not only limited that methodology but also possibly cited the Poe dissent, Obergefell versus Hodges. The court's approach in future cases remain unclear. Matter debate. Substantive due process, text, history, experience by Nathan S. Chapman. Substantive due process. The most controversial due process doctrine is a substantive due process. The doctrine has little support in the text and the history of the Constitution, and it has long ignited political debate. For good reason. Substantive due process replaces popular sovereignty with beautiful unelected Supreme Court justices. The Constitution itself is ordinarily the source of constitutional rights. Its provisions are the fruit for political debate and compromise, the clearest evidence of people's will. Not all constitutional provisions, of course, are perfectly clear. To understand weak terms, courts usually examine prior history, other constitutional provisions, and the subsequent practice. None of this offers strong support for the rights protected by substantive due process. First, those rights find little support in the constitutional text. The Due Process Clause guarantees due process for law. before the government may deprive someone of life, liberty, or property. In other words, the clause does not prohibit the government from depriving someone of substantive rights such as life, liberty, or property. It simply requires that the government to follow the law. One scholar has therefore described the substantive due process as oxymoron, akin to green pastoral readiness. Okay. Nor does the Bill of Rights incorporated into the 14th Amendment due process clause provide textual support for substantive due process. The most that can be said is that the doctrine arises from penumbras or emanations of the specific guarantees in the Bill of Rights, not from those specific guarantees themselves. Griswold versus Connecticut, 1965. One might try to resolve this textual deficit by locating substantive due process rights in other provisions of the 14th Amendment, such as privilege or immunities clause or the equal protection clause. But this would arise another set of textual and historical difficulties. Second, history provides little support for substantive due process. Until the late 19th century, no court held that due process protected substantive rights. The first Supreme Court opinion to even suggest this was the Dred Scott case, 1857. Scott, the slave, argued that he was free because his owner had taken him to territory where slaves was banned. Chief Justice Taney notoriously replied that declaring Scott to be free would deprive his owner of a property without due process of law. The Republicans who enacted the 14th Amendment meant to repudiate that notion, not to apply it against them states. Aside from the Dred Scott case, there is little historical evidence that courts or Congress saw the due process limited the substance of legislation. Third, substantive due process has consistently generated political controversy. The court first applied the doctrine and the term of the 20th century to invalidate state labor and wage regulations in the name of freedom of contract, a notion mentioned nowhere in the Constitution. Those who opposed the labor union movement supported the doctrine, but it became increasingly unpopular with progressives and mainstream Americans during the Depression, and the court used it to swamp New Deal regulations. The national dispute ended in the showdown. President Franklin Roosevelt pressed the Supreme Court to abandon substantive due process. In response, a pivotal justice changed sides, and the court ultimately repudiated the doctrine. This episode demonstrated how hard it is to change the court's constitutional jurisprudence, even when it flies in the face of the text approved by the people. The contemporary version of a substantive due process has likewise upended democratic politics. The most obvious example is abortion, by putting the issue beyond the reach of ordinary politics. In Roe v. Wade, 1973, the court precipitated the cultural war, a realignment of the political parties, and the politicalization of Supreme Court appointments. Some defend substantive due process on the ground that it protects fundamental rights. But Americans disagree about what should count as a fundamental rights, and many think that the fairest way to resolve that disagreement is through political debate. Such debates are not futile. They have resulted in a number of amendments that to expressly protect fundamental rights, such as the freedoms of speech, assemble, assembly, and religion, and the right to vote. Perhaps the best argument for maintaining substantive due process is that the court has a duty to follow precedent. On one hand, sometimes people rely on past decisions. Enforcing those decisions allow people to plan their lives and move on. On the other hand, the court's chief duty is to enforce the law enacted by the people, not to perpetuate doctrines of its own making. Given substantive due process' solid history, it is unsurprising that justices continue to disagree about it. Some current justices would extend it, some would scale it back, and others would drop it entirely. Regardless of the court's future approach, one thing seems certain: substantive due process will continue to foment political controversy. Incorporation of the Bill of Rights. By contrast, incorporation of the Bill of Rights against states applying some its provisions to state governments as well as the federal governments is far less controversial. Although the text of the history of the Due Process Clause may not support the incorporation of every provision of the Bill of Rights, between the Due Process Clause and other clauses of the 14th Amendment, incorporation is on solid ground. Some continue to urge the court to apply all the provisions of the Bill of Rights against the states. Conversely, others argue that applying some provision to the states was a mistake. In particular, some scholars and judges argue that it makes little sense to apply the Established Clause of the First Amendment to the states. The Established Clause originally prohibited Congress not only from establishing a federal religion, but also from interfering in a state establishment. In part, then, the clause protected state establishments, it did not prohibit them. Despite this history, the court is unlikely to reverse course, prohibiting state religions, establishments, and broad political support. And it enforces the religious liberty secured against the states by the incorporation of the Free Exercise Clause. The next perspective, not whether, but how, discerning new constitutional freedoms, by Kenji Yoshino. One of the most vibrant and contentious debates relating to the Due Process Clause concerns the substantive due process, jurisprudence. Under this area of law, the Supreme Court and protected rights not specifically listed in the Constitution. Currently, such unenumerated rights include the right to direct education and the upbringing of one's children, the right to procreate, the right to bodily integrity, the right to use contraception, the right to marry, the right to abortion, and the right to sexual intimacy. For well over a century, the court has grappled with how to discern such rights. The controversy continued to this day, and the court's 2015 decision in this area, Obergefell versus Hodges, breaks new ground in that storied debate. The debate about whether the court should be in the business of recognizing such rights has raised legitimate concerns on both sides. On the one hand, when the court struck down state law, for example, a prohibition on same-sex marriage, because it violates a right that is not specifically mentioned in the Constitution, the court ran the risk of facing amplified charges of judicial activism. It's one thing when the court struck down a legislative enactment based on some specific rights spelled out in the Constitution. It's quite another thing when it invalidates such enactment based on a right that has not textual basis within the Constitution. The theory that the 5 justices on the United States Supreme Court will make a law for the entire nation based solely on their personal policy preferences, given that they have no text to guide or constrain them. The court itself once said it has already been reluctant to expand the concept of full substantive due process because guideposts for responsive decision-making in this uncharted era are scarce and open-ended. Collins was Harker Heights, 1997. Yet it did just that and undermines the fundamental fabrics of society and the cultural norms based on political pressure or the current trend, or indeed political activism from other factions or partisan affiliations, which is very, very dangerous. It's literally eroded the foundation and the premise of the Constitution. Anyway, that's my own comment. On the other hand, the idea that the Constitution only protects rights that are specially mentioned is also deeply problematic. Even the staunchest textualist must account for the 9th Amendment, which states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. As such, the amendment provides a textual warrant for finding textual unenumerated rights in the Constitution. The ethos behind the 9th Amendment also seems sound. No Constitution could purport to enumerate every single right that people might deem fundamental. On natural law's grounds, most individuals would probably bristle at the idea that they lacked a constitutional right to marry. Finally, as a purely doctrinal matter, over a century for presidents guarantee such unenumerated rights under the 14th Amendment due process clause, few, if any, justices on the current court appear to take the position that all rights listed above should be rolled back entirely. The live debate, then, is not whether to recognize unenumerated rights, but how to do so. While a full discussion of the methodological debate could not be elaborated here, we can contract 2 major approaches. In 1997, the court issued a landmark decision that set forth a more restrictive methodology. The issue in Washington versus Glansberg was whether an individual had the right to physician-assisted suicide. The court rejected the existence of any such right. In doing so, it articulated a general 2-part test for how such rights should be found. First, it observed that the right had to be deeply rooted in this nation's history and tradition, and implicit in the concept of orderly liberty. Second, required a careful description of the liberty of interest and issue. The first restriction, that a right must be deeply rooted in history, ensured that due process would be, as one scholar has put it, backward-looking in order to safeguard against no developments brought about by temporary majorities who are insufficiently sensitive to the claims of history. The second restriction, careful description of the liberty interest at stake, ensured that the jurists would not be able to claim that no right was deeply rooted in history by describing the right at a higher level of generality. For instance, arguing that while the physician-assisted suicide had not been traditionally protected, the right to control one's own body was. And this example suggests the level of generality in which one can's particular right will often determine whether a tradition supports it. In 2015, however, Obergefell versus Hodges dramatically changed the substantive due process methodology. Obergefell will probably be best known now and in the future, and the case that held that a same-sex couple have the right to marry. However, its more overarching contribution to constitutional law may well lie in the savingly wholesome revision of the Glassberg text. After all, on the Glassberg, it was clear that same-sex marriage was not deeply rooted in the nation's tradition and history, and if the right had to be specifically described in order to be protected, then the right to marry is too general to protect the right to same-sex marriage. So how did Obergefell reach its result? The answer was, and Chief Justice Roberts noted in dissent, that Obergefell effectively overruled Glassberg. First, it put an end to the idea that the due process methodology was backward-looking, amplifying a comment made in the 2003 case, Justice Kennedy's majority opinion observed that the nature of injustice is that we may not always see it in our own times. He elaborated the generation that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions, and so they entrust to future generations a charter protecting the freedom of all persons to enjoy liberty as we learn its meaning. Put differently, Justice Kennedy observed that the refusal of the framers of the 14th Amendment to specify which liberties were protected meant that they intended to leave the meaning of that concept to the judgment of subsequent generations. In doing so, he struck the shackles of history from the due process analysis. Similarly, Obergefell also challenged, although less categorically, the notion that the court has to offer a careful description of the right. Justice Kennedy observed that while the careful description methodology may have been appropriate for the right at issue in Glassberg, physician-assisted suicide, it is inconsistent with the approach this court used in discussing other fundamental rights, including marriage and intimacy. He noted that when interracial couples or prisoners sought to marry, the court did not construe the right as the right for interracial couples or to marry, or the rights of prisoners to marry, but simply as the right to marry. It simply rejected the idea that the court should not climb up the ladder of generality in analyzing the right presented. And while he explicitly declined or ruled Glassberg on this point, he also did not offer a principal distinction between why the rights of marriage and intimacy might differ from other rights. Obergefell represented a clear victory for those who believe, as many progressives do, in a more expansive vision of substantive due process jurisprudence. At the same time, it announced unlimited discretion for the judiciary in this area. Instead, it endorses the approach taken in canonical dissent by Justice Harlan in the 1961 case of Poe versus Allman. The Poe dissent rejected by formulaic approach to substantive due process in favor of a more open-ended common law approach, whereby courts address questions about fundamental rights case by case, striving in each decision to balance the constitutional respect for individual liberty and the demands of organized society. It remains to be seen what the future rights such an approach might yield.